So good evening, ladies. Welcome to tonight's talk show. I am your host, Kat. So tonight, I am with three empowered independent women from the three independent commissions of the Philippines. Let me introduce you to our guest, Miss Jeff from the Civil Service Commission, Miss Cariz from the Commission on Audit, and Miss Jenny from the Commission on Election. All right. So tonight, we are going to talk about our Philippine Constitutional Commissions under Article 9 of our 1987 Constitution. May I start this discussion by giving you a brief background about these constitutional commissions? So there are three independent constitutional commissions laid down in our Constitution. They are the CSC, the COMELEC, and the COA. They are composed of a chairman and commissioners who are appointed by the President and shall have a tenure of 7 years. These commissions are constitutionally created and may not be abolished by any law or statute. Each of them are conferred with certain powers and functions which cannot be reduced, and they may also promulgate their own set of rules as stipulated in the provisions of Article 9.
Yes, you are right. So, although we in the CSC and also with COMELEC and COA may promulgate our own set of rules, albeit the constitutional guarantee, we are bound to limit its implementation and interpretation in accordance with our laws and constitution.
Yes, that is exactly what was held in Trade and Investment Development Corporation versus the CSC. Also, in the case of Arruelo versus CA, the Supreme Court held that although you may promulgate your own set of rules, the rules concerning pleading practices and procedures in all courts are still under the jurisdiction of the Supreme Court.
I agree. As a constitutional commission, we are also bound to decide by a majority vote of all our members before we can enforce such. Would you know how we do the counting for a majority vote?
Um, I think so. Way back in 1987, the commissions were following the CUA doctrine, wherein the courts held that 2:1 decision rendered by the First Division of COMELEC was valid since three members of the commissions who voted affirm a decision is considered a majority vote. But now we are bound by the jurisprudence under the case of Estrella versus Comelec, where it abandoned the CUA doctrine, saying that Comelec and Bank shall decide a case or matter before it by a majority vote of all the members and not majority of members who deliberated or voted thereon.
Yes, that's correct. So you are updated, Kat. And also, every decision we come up to may be brought to the Supreme Court for certiorari, of course.
Yeah, I also know the history of that. In the case of Mansita versus Barcinas, the CSC was held as a single arbiter of all the contests relating to civil service, and as such, its judgments are unappealable and subject only for certiorari judgment in the Supreme Court. But here comes the case, Mateo versus Court of Appeals, wherein it abandoned the Mancina Doctrine, saying that as amended by Revised Administrative Circular 1-95, which took effect in 1995, final resolutions of the CSC shall be appealable to the Court of Appeals. But the RTC has no jurisdiction to entertain such cases involving dismissal of officers and employees covered by the Civil Service Law.
Yes, that is correct. I appreciated that you are updated with the cases which involve us, the CSC. So with that, I would also like to enlighten you with the functions of the Civil Service Commission. So I'm sure that you have heard that the Civil Service Commission, you hear it all the time, especially when you want to work in the government, right? So your family or even your friends would tell you that you need to comply with the requirements of the Civil Service Commission. So now I will tell you more about the CSC. So let us start with Section 1, Article 9 of the 1987 Constitution. So the requirements to be a chairman and a commissioner is almost the same as the other commissions, like the Commission on Audit and COMELEC. The only difference is that you must have the capacity for public administration. So the reason for this is because bulk of the work in the Civil Service Commission requires for public administration. And that is why in the old constitution, it was only required that you be a college graduate. But now this was increased to such. I think that's
Um,
awesome, right?
yeah, it
Mhm.
is. Anyway, I am just curious, but what exactly is the scope of this CSC? And are universities which are owned by the government being a public institution also under this section?
Yeah, so before I answer that, the scope of the CSE is actually very broad. So it covers all branches, subdivisions, instrumentalities, and agencies of the government. And now it includes government owned or controlled corporations with original charters. So to answer your question, actually, in the case of UP versus Regino, the respondent was dismissed by the UP for leaking final examinations. So a case ensued and it was brought to the Civil Service Commission, which ordered her reinstatement. Of course, UP was unhappy with that, right? So the decision, and so they claimed that the power to discipline the employees of the UP was within the board and not the CSC. However, the Supreme Court said that as a mere government-owned or controlled corporation, the UP was clearly a part of us, the civil service, and under the 1973 Constitution, and now continues to be so because it was created by a special law and has an original charter. So basically, the employees is under the appellate jurisdiction of the Civil Service Commission.
So, thank you for that. In the topic of discipline, what is the scope of the Civil Service Commission?
I think it is inherent that they have this power to make sure that the public is given the best service. So, in the case of Orlando versus Bugayong, it was ruled that disciplinary cases and cases involving personal actions affecting employees in the civil service, including appointment through certification, promotion, transfer, reinstatement, etc., are within the exclusive jurisdiction of the Civil Service Commission, which is actually the sole arbiter of the controversies relating to civil service.
Oh, so if the CSC can discipline employees, can they also choose an appointee in the government just to make sure that they will be in high morale per se?
No, they cannot. Um, so in the case of province of Camarines Sur versus the Court of Appeals, it was ruled that the CSC can only inquire into the eligibility of the person chosen to fill a position. And if it finds the person qualified, it must so attest. So if not, the appointment must be disapproved. So basically, the duty of the CSC is only to attest appointments, and after that function is discharged, its participation in the appointment process ceases. And just to add on to it, in the case of Luego versus CSC, the CSC disapproved a permanent appointment on the ground that another person is better qualified than the appointee. So the Supreme Court said that that cannot happen because the Civil Service Commission is not empowered to who the appointing officer can appoint. Its authority is only limited to approving or reviewing the appointment in the light of the requirements. So, besides, the Constitution itself provides that an officer or employee can only be removed or suspended if there is a law that supports such.
Oh, so what are the rules in terms of appointments? I think from what we have discussed before, there are some government officials who cannot be appointed, right?
Yes. Yeah, we have discussed it before in the executive department. If you could remember, in here, Section 7, Article 9B is applicable in the case of Civil Liberties Union versus Executive Secretary. So it was actually ruled there that this section is meant to lay down the general rule applicable to all elective and appointment public officials and employees, while Section 13 is meant to be the exception that applies only to the president. So, just to make sure that the president will not abuse the power or his alter egos.
Mhm. So, what about double compensation? I being from the Commission Audit, is important that you can discuss this to us.
Yes, of course, I'm curious. Well, as a general rule, double appointments are prohibited unless it be proved that it is not incompatible. For double compensations, as a general rule too, it is prohibited unless there is a law that specifically allows it. And this was actually discussed in Kimson versus Ozeta. But we have to remember that double compensation does not necessarily mean double appointment. So someone can be twice compensated even if in the same position. For example, pensions and such. So, but these are actually allowed, the pensions. So, nevertheless, as I said, it is generally prohibited.
So thank you for that. Now I just remembered during my time as an employee of SSS, of course, we were under the CSC being a GOCC. However, I was always wondering why we could not go on a strike even if some employees wanted to.
Yeah, that's a good question because although the Constitution safeguards the right to organization, the employees of the government cannot go on a strike because this was actually explained in SSS Employees Association versus the CA. So striking is not permitted because the terms and conditions of their employment is fixed by law, unlike in private corporations, of course. And moreover, a government employee must render service for the public. So it is logical that if the public pays the government employees, then they cannot simply just, remove their right to public service just because of a strike.
Right. So earlier, you were talking about family members who are advising others to comply to the requirements of the CSC. What exactly is that?
Well, if they have one thing in common in the civil service eligibility, it is required for all government employees. But there is an exception. If you render efficient service for 7 years, then you are exempted as mandated by RA number 6850.
So really, I did not really know that. Then what about those who are not required to take up the competitive examinations then?
Well, in the case of Salazar versus Matay, primarily confidential position do not require such, but in said case, once the confidence is lost, then the position is also lost. So in this case, the act of taking an oath for another position was already a loss of confidence. But another one that is also exempted is highly technical positions, because of course it would be illogical if someone who possesses such high skill would not be given security of tenure compared to those who are non-technical but they have security of tenure, right?
That makes sense. Well, thank you, Miss Jeff. Let us move on to the COMELEC. Miss Jen?
Yeah, anyway, in the COMELEC, we are composed of one chairman and six commissioners, and majority of us are all members of the bar and who have been engaged in the practice of law for at least 10 years.
Oh, wow, 10 years. How do you know if lawyers are really in practice?
Actually, there was an old case, Cayetano versus Monsod, wherein, in this particular case, Attorney Monsod was appointed as the chairman of the COMELEC, but was questioned on the grounds that he was not a practicing lawyer. And in this case, the Supreme Court laid down what is the spirit of the practice of law.
Isn't it just appearing in court and interrogating witnesses?
Actually, no. The practice of court is not limited to the conduct of cases or litigation in court, and practice of law means any activity in or out of the court which requires the application of law, legal procedure, knowledge, training, as well as experience.
Oh, I see. So as long as we perform those acts which are characteristics of the profession, then we are in the practice of law.
All right. So let me introduce to you the duties and functions of COMELEC since the election is quite near, and we might as well look into the particular duties of the commission.
Mhm. So, aside from the local and national elections and registration of voters, what are your other jurisdictions?
Well, we are also in charge of the conducting of plebiscites, referendums. We are also the tribunal who has the original jurisdiction over all contests relating to the elections, returns, and qualifications of all elective regional, provincial, and city officials. We also decide all questions affecting elections, including determination of the number and local of the polling places and appointment of election officials and inspections. And take note as well that we also have the power to deputize law enforcement agencies and instrumentalities of the government. This actually includes the armed forces of the Philippines for the exclusive purpose of ensuring free, orderly, honest, peaceful, and credible elections, but of course with the concurrence of the president, since he is still the commander in chief.
Are you divided into divisions and bank for deciding cases too?
Yes, actually, all election cases shall be heard and decided in division, provided that motions for reconsideration of decisions shall be decided in bank. And also, in the case of Sarmiento, way back 1992, the Supreme Court set aside the resolutions of COMELEC. Because they took original cognizance of an election case like the pre-proclamation case without referring them to the appropriate division first. And also, sometime in 2003, in the case of Bautista, it was reiterated that a petition to cancel a certificate of candidacy shall be under the jurisdiction of COMELEC in division and not in bank. And also, COMELEC has the power to regulate and supervise the operation of transportation and other public utilities and the media of communication of information. And it was held in telecommunications and broadcast attorneys of the Philippines versus GMA network that COMELEC allocation time and space of political ads in media is not a suppression of freedom of speech, but only a regulation of the time and manner of advertising.
Yeah, thank you. I'm just curious. I think I have read somewhere that before the Comelec prohibited the use of media for the political campaigns of the candidates, but now it is again permitted. So why is that?
It's actually simple because it is unfair. I mean, it would be disadvantageous to unpopular candidates, unlike those who are already or who already ran before or were already known, right? So besides, if they prohibit airtime, rich candidates can use or can just use helicopters or other paraphernalia to campaign themselves. This was highlighted in the case of Adjong versus Comelec, that the constitutional objective to give a rich candidate and a poor candidate equal opportunity to inform the electorate as regards their candidacies is not impaired by posting decals and stickers on cars and other private vehicles. And doing so will only or will also infringe on their right to free speech, and neither can Comelec ask for free airtime for the purpose of giving equal airtime for the candidates without a just compensation, because that will be illegal expropriation.
Okay,
All
so
right,
thank you so
so
much,
let's move
Miss
on
Jim.
to the Commission on Appointments. On audit, I mean, Miss Kaz.
Thank you, Miss Kathy. The Commission on Audit is the watchdog of the financial operations of the government, and its role is to check the stability of our government, and it depends to a considerable degree on the integrity of its fiscal policies and transactions. So, a vigilant and conscientious Commission on Audit can eventually trace irregularity and mismanagement of public funds. So yes, COA is also composed of a chairman and two commissioners. So they must be a certified public accountant with not less than 10 years of auditing experience, or they should be members of the Philippine Bar who have been engaged in the practice of law for at least 10 years. Um, so yeah, I think that's it for the intro for COA.
Can you briefly explain the powers and duties of COA?
Mhm. So, the broad powers of the Commission are to examine, audit, and settle all accounts pertaining to the revenue and receipts of and expenditures or uses of funds and properly owned or held in trust or pertaining to the government. On post-audit authority, constitutional commissions and bodies of or offices are granted fiscal autonomy under the Constitution. Autonomous state colleges and universities, other government owned or controlled corporations and their subsidiaries, and non-government entities receiving subsidy or equity directly or indirectly from or through the government. So in Bustamante versus COA, COA Circular number 756, prohibiting the use of government vehicles by officials who are provided with transportation allowance was held to be a valid exercise of its power under the Constitution.
Also, are there instances where COA disallowed agencies?
Yes, a good example of their power to disallow would be in the case of Orosio versus COA, wherein the Supreme Court held that COA has the power to overrule the National Power Corporation, General Counsel on post-audit measures relative to the determination of whether an expenditure of a government agency is irregular, unnecessary, extravagant, or unconscionable. Also, in the case of Sambeli versus Province of Isabela, COA exercised the regulatory power when the provincial auditor saw an overpriced purchase of equipment by the city from ECS Enterprise. COA contended that improper or wasteful spending of public funds or immoral use of government property is unnecessary or scandalous and extravagant, and it offends the sovereign people's will. But in the case of Osmeña versus COA, COA committed grave abuse of discretion when it disallowed Cebu City's appropriation that was made for an agreement for an amicable settlement participated in by Cebu City.
So what is the extent of auditing authority of COA over GOCCs?
Okay, so thank you, Miss Kathy. COA has audit jurisdiction over GOCCs with original charters as well as GOCC without original charters. So in the case of PAL versus COA, Philippine Airlines have ceased to be a GOCC and is no longer under the audit jurisdiction of the Commission on Audit. So I think that's all for COA.
Yes, that is all for tonight. Thank you so much for listening, and I hope to see you in the next episode of our show. Have a good night.
Thank you.